Greetings to my fellow researchers and audience. On this beautiful day, here gather the most dedicated, diligent, and inspiring researchers in our institution. Without further ado, may we now all introduce ourselves.
안녕하세요. My name is Alice Tan Kai-shin. I am a junior legal researcher.
Konnichiwa, I'm Yoani, one of the legal researchers of this group.
Ciao, Wanhua here, a legal researcher reporting for duty.
Hola, I'm Shannon Kuwanyi, a junior legal researcher of this group.
Bonjour, I'm Ng Joyan, the leader of this group. We have received a request from our fellow client, Ms. Puteri Sophia, to conduct a legal research. Let us now put all of our attention to the big screen.
As you have been reading the news, the number of COVID-19 clusters are all derived from workplaces. So I need all of you, a team of researchers, to do a research, a legal research, whether employers in Malaysia can make vaccination compulsory for its employees. Please help us.
My fellow peers, what do we say for this request?
Yes.
Yes. Yeah, sure.
All right, now I announce we accept this request from Ms. Puteri Sophia.
The main question brought up from the request by Ms. Puteri is whether employers in Malaysia can make vaccination compulsory for its employees. This can be further derived into a few sub-questions, and we will divide ourselves into 3 groups to tackle these questions. Firstly, Wan-Ning and I, Alice, will talk about the application of law in Malaysia regarding the main issue and whether employees can refuse to be vaccinated. Subsequently, Joyan will discuss on the question whether employers should leave the choice to be vaccinated entirely in the hands of the employees. Next, Shannon and Wanhua will present on whether employees can be terminated from employment or be subjected to disciplinary action if they refuse to be vaccinated. Lastly, I will end with a conclusion. Without further ado, let's start with the presentation. Presently, Malaysia is encountering a deadly infectious disease called coronavirus disease 2019. The disease is transmitted through respiratory droplets and direct or indirect contact with the mucous membrane of the eyes, nose, and mouth. To reduce the transmission, Malaysia government and Ministry of Health have taken necessary measures, such as implementing movement control order, where only essential businesses were allowed to operate. This has adversely affected the economy and financial market in Malaysia. On 24th of February 2021, the immunization program started. Safe and effective vaccines can protect individuals against the disease, and they are most effective against serious illness and death. Many businesses in Malaysia wish to have their employees fully vaccinated so that they can reopen. However, the issue arose whether employers can make it compulsory for all the employees to do so. I will start with explaining the application of law in Malaysia regarding this main issue. Section 2, subsection 1 of Employment Act 1955 interprets employer as any person who has entered into a contract of service to employ any person in any capacity, whereas employee is any person or class of persons included in any category in first schedule to the extent specified therein. Based on my research, currently there are no statutory provisions and common law in Malaysia that permits employer to make vaccination mandatory to his employee. This is because the first COVID-19 case was detected in Malaysia on 25th of January 2020, and it is a relatively new issue here. Besides that, the government of Malaysia has not made vaccination mandatory at this moment, and the World Health Organization also does not foresee this being made mandatory in the future. Therefore, the employer has no legal power to mandate the vaccination to their employees before returning to work. However, there may be exceptions. Section 16 of Occupational Safety and Health Act 1994 makes it very clear that every employer is obliged to prepare and revise a general policy concerning the safety and health of his employees at work. A safe place of work is also part of the workers' safety and health. Therefore, employer may consider these three circumstances before they impose a mandatory vaccination. Firstly, which industry sector does the business belong to? The employer may consider if they are essential businesses. Secondly, what type of work do they perform? Are there any doable approaches for the business to remain operating without imposing a mandatory vaccinations? Possible measures might be allowing the unvaccinated employees to work from home or segregating the vaccinated employees and unvaccinated employees at work. The last circumstance to consider is the vulnerability to the workforce. For example, people who work in child and elderly care sectors shall all be vaccinated because they are more likely to be exposed to vulnerable parties and threaten their health. Therefore, I would conclude my part by saying that, till now, employers cannot make vaccination compulsory for his employees due to the lack of support in law. However, there may be circumstances where they may mandate vaccination.
Can employees refuse to be vaccinated? Yes, they can. Every person in Malaysia has their own freedom of choice to choose whether to receive the vaccinations or not, and even the country doesn't have the power to interfere them, not to mention the employers. This can be seen in the Federal Constitution's Part 2, Section 5, Subsection 1, which stated clearly that no one shall be deprived of his own life or personal liberty according to the law. Personal liberty, in the ordinary meaning, means liberty relating to or concerning to the body of the individuals. Vaccinations is relating to the body of individuals as it is injected to his arms. Thus, every employee has the right to make his own decisions. Apart from that, in the Malaysia case, Nguyen Jo Mien and Lee Chang Fu and others, we can see that if a patient has been undergoing a medical treatment without any of his concerns when he is in a state of sound mind, it will be unlawful touching or battery. This principle applied in Nguyen Jo Mien and Lee Chang Fu and another can be applicable in the future if any similar disputes arise. Hence, making forceful vaccinations an unlawful act. Moreover, Lord Justice Butler Source in Re-MB and Adult Medical Treatments has mentioned that a sound mind patient can refuse any concerns for medical treatments using his own right. Whatever the reasons he refused the treatments may be, reasonable or unreasonable, or no reason at all, even to the extent that it may cause his own death, we need to respect his decisions. Therefore, it can be said that an adult can choose to receive a vaccination or not, considering he is in a sound mind, as it is every individual's basic human right to decide what to do with his own body as established and protected by the common law. Although employees can refuse to be vaccinated, there may still be some exceptions. According to Occupational Safety and Health Act 1994, Section 24, Subsection 1, Paragraph D, an employee is expected to obey every instructions or measure set by the employers as long as it is not illegal or unreasonable. So, if employers find it necessary for the workforce to get fully vaccinated to adhere to the Act after contemplating some circumstances mentioned by Alice before, then the employee has the duty to obey these instructions, especially some industries such as food and beverage, education, etc. Then, what will happen if an employee purposely disobey or disregard the employer's reasonable orders? This will amount to an act of insubordination, which may lead to terminations of contract or disciplinary actions, which will be further discussed by Wan Hua and Shannon later. This can be supported in two Malaysia cases, which are Nguyen Woon Yen and Sungai Wong Plaza Sdn Bhd or Landmarks Holdings Sdn Bhd, Tuan Haji Muhammad Noor Saudiman, and Federal Power Sdn Bhd. The Federal Court and Industrial Court established a similar idea, which simplifies into an employee is obliged to comply with the employer's instructions with full cooperation as long as it is lawful and reasonable to ensure the ambience of the workplace will be harmonious and the work efficiency will be maintained. as his basic considerations, just as providing remunerations is the basic considerations of his employers. However, employees who refuse to be vaccinated out of medical reasons, such as pregnant women or pre-existing health conditions, are more risky than ordinary people. Therefore, they can refuse to be vaccinated and cannot count as insubordinations. For these employees who refuse to be vaccinated, employers can come up with temporary solutions by relocating them to working positions which require less contact with other employees or continue to work from home. In conclusions, employees can refuse to be vaccinated. However, there are still some exceptions, so it's up to the court to decide based on the facts if there are any disputes relating to these issues.
Thank you, Wan Ning, and I will continue from here. Through the presentation by Wan Ning and Alice, we know that employers could not possibly make vaccination compulsory for all employees due to their personal liberty. Hence, you might be wondering, what could an employer do, and also whether employers should leave the choice to be vaccinated entirely in the hands of the employees. As reported by the Edge Market, the Health Ministry detected 19 more COVID clusters as the 17th of September 2021, and 11 out of 19 of them are related to workplaces. This shows the significant contribution of workplaces to the COVID-19 cases in Malaysia. After looking at the statistic, should the employers just leave the choice to be vaccinated entirely in the hands of the employees? No, absolutely not. Employers are imposed with a legal obligation to ensure the safety and health of the employees in the workplace pursuant to Section 15, Subsection 1 of the Occupational Safety and Health Act 1994, which hereinafter will be referred as the OSHA. With that being said, employers must practice reasonable behaviors as far as practical in the workplace to ensure the safety, health, and welfare of the persons at work. In this era of pandemic, the protection from exposure to the COVID-19 viruses in workplaces is particularly crucial. Furthermore, employers also owe a duty to practice reasonable steps in ensuring the safety and health of any third parties that are not his employees under the OSHA 1994 Section 70. A failure in adhering to the obligations mentioned in Section 15 and Section 17 could result in a penal sanctions of a fine not exceeding 15,000 ringgit or to imprisonment of a term not exceeding 2 years or to both. Therefore, the right and freedom of an employee to vaccination should be weighed against the legal obligation placed on the employers. After listening to all the laws and penalties, you might be wondering what could an employer do to avoid a breach of the obligations. Even though employers do not possess any legal power in making vaccination a must for the employees do have the right to encourage and educate their employees so that they can get vaccinated for the sake of themselves as well as the people around them. First and foremost, the employers should perform an assessment on the risk of exposure to the COVID-19 viruses to their employees as well as any third parties while operating in a particular industry as mentioned by Alice. Secondly, upon relying on the assessment, the employers could then decide if making vaccination mandatory is reasonable and necessary in protecting their workforce. After that, the employer should share this piece of information to the employees, as well as other information such as availability and platform to obtain vaccinations, as well as any reliable sources of information that employees could refer to, as obliged by the OSHA 1994, Section 15, Subsection 2, Paragraph C. Some employers even took a step further by providing free vaccinations to their employees under programs such as Selvax. Furthermore, employers should also remind the duty of the employees pursuant to the OSHA 1994, Section 24, Subsection 1, which will be further discussed by Wan Hua in her presentation later. The consequences of getting fined and imprisoned under the OSHA 1994 Section 24, subsection 2, in which of the provision mentioned above should also be highlighted to the employees. In conclusion, instead of letting the employees do whatever they wish to do, employers should encourage the employees to consider vaccination thoroughly by providing them necessary information and educating them on the legal obligations placed on their shoulder as well as the employers.
Moving on to the next question. If employees refuse to be vaccinated, can they be subjected to certain disciplinary action? Before we dive into the question itself, it is significant to look into the duties that should be performed by an employee. As Joanne has stated earlier, from the Occupational Safety and Health Act 1994, Section 24, subsection 1, paragraph A, by getting vaccinated during this rampant pandemic, employees can assure a certain degree of safety and health of himself and reasonably care for the others around him. In addition, Wan Ning has previously stated that by virtue of the OSHA 1994, Section 24, subsection 1, paragraph D, it suggests that if an employer sets out instruction for occupational safety and health, such as following certain SOP is a mandatory, it leaves the employees no choice but to adhere to the instituted regulations. In the article Company COVID-19 Vaccination, where the refusal by employee justifies termination, under the two cases which were brought up by Wan Ning, also mentions that workers are expected to obey the legitimate directives in relation to vaccination requirements before they resume their work or enter the workplace. Presence of any willful disobedience is regarded as an act of insubordination that undeniably undermines any undertaking's orderly system. In Section 24, subsection 2 of OSHA 1994 lays out that a person who contravenes the provision of this section shall be guilty of an offence and shall be liable to a fine not exceeding 1,000 ringgit or to imprisonment for the term not exceeding 3 months or to both. It is now certain that, according to this provision, an employee will have certain penalty of fines or incarceration if there is any breach of duty present. Section 25 of the same Act further increases the penalties if there is evidence showing that the employee intentionally, recklessly, or negligently interferes with or misuses anything provided or done in the interest of their safety, health, and welfare. As reported by the Star, employers can take progressive disciplinary action against obstinate employees according to the severity of the misconduct. Progressive disciplinary action is a process whereby an employer takes disciplinary action against an employee in a progressive manner. From the least to the heaviest intensity, the types of disciplinary action include counseling employees, issuing warning letters, issuing show cause letters, suspension, conducting domestic inquiry, and finally, dismissal. However, any action taken must follow the proper disciplinary procedure. Knowing the process under the regulation and following it step by step will reflect the fairness of an employer and can avoid being challenged for wrongful dismissal or dismissal without just cause, thus minimizing the industrial court cases for unlawful dismissal. However, based on an article, the task of determining whether the dismissal was with or without just cause lies in the hands of the industrial courts by using the reasonable objective test approach. The handling of misconduct and some of the related clauses is regulated under Section 12, 13, 14, and 15 of the Employment Act 1955 and also in Section 20 of the Industrial Relations Act 1967. If an employer acts with due care in taking disciplinary action, the courts will not intervene. All misconducts and non-disciplinary acts must be investigated to identify whether they are minor or major in nature. According to the report, a major misconduct is any act of indiscipline or behavior that causes substantial harm and damage or even adversely affects the reputation of the employer's personnel and assets. Some examples of major misconduct are insubordination, negligence of duties, failure to observe safety rules, and other similar acts. As mentioned before, measures taken are dependent on the merits of the case. Therefore, the answer to the question of whether an employee will be subjected to disciplinary action if they refuse to be vaccinated is perhaps a clear yes.
Continuing, I'll be touching upon the subject of whether termination of employment can be justified for refusal of getting the vaccination. Firstly, to define the word termination, which is basically an ending of a contract. As mentioned by the Federal Court, in the case of Dr. Adat and Asanta Hospital, which stated that there is no material distinction between termination and dismissal, as in either case, it must be grounded on just cause or excuse as per Industrial Relations Act 1967, Section 20, subsection 1. Besides that, an employer can terminate a contract of service at any time as long as the length of notice given by the employer to the employee is as per what is required in the Section 12, subsection 2 of the Employment Act 1955. However, it is noteworthy that the provision above is not applicable when employees fail to dismiss employees with just cause or excuse pursuant to Industrial Relations Act, Section 20, subsection 1, as mentioned by the Court of Appeal in the Omar bin Othman and Cooling Advanced Technology Sdn Bhd case, which under Employment Act 1955, Section 12, subsection 3, the Act mentioned the common reasons for the termination of the contract of services. Passing on the next question of whether refusal to get vaccinated is a reasonable and just cause for the employers to dismiss or terminate to the contract of an employee. Yes, I would say that the refusal to get vaccinated can amount to a just reason for termination of employment, especially those who are having frequent and close contact with individuals such as police or those in the frontline workers, especially when they are in the medical field. As reported by an article, Inspector General of Police Tan Sri Abdul Hamid Badr said that police who refuse to take the COVID-19 vaccine will be asked to resign. However, it also depends on the reasons for the refusal of vaccination. Here are a few exceptions. For example, for those who have certain personal medical conditions that are proven to be unsafe to be vaccinated, such as pregnant women or those people who have allergic reactions to the substance of the vaccine, or any other health problems that are related. Other than personal medical reasons, I would say that it is fair to terminate those who refuse vaccination. As mentioned by the Ministry of Health and the Prevention and Control of Infectious Disease Act, Section 18, subsection 1, which stated that an authorized officer is allowed to demand disinfection and closure of premises if they have reasonable grounds or beliefs that any person on the premises has an infectious disease which is likely to lead to a spread of disease. It creates a situation where the organization are obligated to shut down for 14 days to conduct sanitization, which puts any operation at risk of economic loss. Also, in the Prevention and Control of Infectious Disease Act 1988, Section 12, subsection 1, expressed that no person who knows or has reason to believe that he is infected shall expose others to the risk of infection by his presence or conduct in any public place or any other place, used in common by the persons other than the members of his own family or household. As COVID-19 is scientifically proven to be highly infectious, there is always a possibility for any person, especially those who are not vaccinated, to be infected with COVID-19, which pose a possible threat to public health, especially those frontline workers that are in contact with numerous people daily. Therefore, when a vaccination is required by their employer, employees can be dismissed if not complied without legitimate reasons. For instance, information from unreliable sources, as they are disrupting the employee's legal obligation under Part 4 of the Occupational Safety and Health Act 1994, which is to provide a safe and hazard-free working environment to all staff at work. In addition to that, Section 24, subsection 1A of the Occupational Safety and Health Act 1994 also mentioned that it is the duty of employer to take reasonable care for the safety and health of others who might be affected. Lastly, I would like to add that it is no longer the rights and liberties of oneself stated in the Federal Constitution, Part 2, Article 5, subsection 1, as vaccination is not only for the prevention of the health of oneself, and it poses threat to harm the safety and health of the public as well. Hence, termination from employment can be justified if you refuse to vaccinate without reasonable grounds.
In conclusion, employer cannot make vaccination compulsory for his employees. This is because employees may refuse to be vaccinated due to personal health reasons. However, it is part of the employer's duty to take reasonable care of their employees' health. Therefore, employer cannot leave the choice to be vaccinated entirely in the hands of the employees. Lastly, employees may be terminated from employment or be subjected to disciplinary action if they refuse to be vaccinated.